ಅಲ್ಲಿ ಮೇಲೊಂದ್ ಕಡೆ ಬರ್ಕೊಳ್ಳಿ. ಅಪೂರ್ವ SK, the investigating officer is present before the court, presence is noticed. Yes. ಇದೇನು ಇನ್ಫ್ರಕ್ಚಸ್ ಆಗಿದೆ ಅಂತ ಲಾಸ್ಟ್ ಟೈಮ್?
ಇಲ್ಲ, ಇನ್ಫ್ರಕ್ಚಸ್ ಆಗಿಲ್ಲ.
ಮತ್ತೆ
pursuant to the direction passed by the Samal.
ನೀವು ಒಬ್ರು ಪಾರ್ಟಿ ಇನ್ ಪರ್ಸನ್ ಗೊತ್ತು, ಅಲ್ಲಿ ಪಾರ್ಟೀಸ್ ಇನ್ ಪರ್ಸನ್ ಯಾರ್ಯಾರು? ಯಾರಿಲ್ಲ. ಸರಿ.
Pursuant to the direction.
ಯಾರು ಬ್ಯಾಂಡ್ ಹಾಕಿಲ್ಲ.
Pursuant to the direction issued by the Samal court.
ಈಗ ಕ್ರೈಮ್ ರಿಜಿಸ್ಟರ್ ಮಾಡಿದಾರಂತ.
ಅಲ್ಲ, the Tahsildar has filed a complaint against me based on the complaint.
ಅದನ್ನ ಸ್ಟೇ ಮಾಡಿದೀನಲ್ಲ ನಾನು.
ಅದರ ಸ್ಟೇ ಆಗಿದೆ. That it is
ವಾಶ್ ಮಾಡ್ಬೇಕು.
My submission.
I have submitted the
respondent. I appear for on behalf of respondent number 2 complaint.
ತಹಶೀಲ್ದಾರ. ವೆರಿ ಗುಡ್. ಎಸ್. 10 ಲಕ್ಷ ಕೇಳಲಿಲ್ವಾ?
I have never demanded.
ಆಡಿಯೋ ರೆಕಾರ್ಡಿಂಗ್ ಇದೆ ಸರ್.
Is not with somebody's.
ಇವ್ರು ಕೇಳಲಿಲ್ಲ ಬಿಟ್ಬಿಡಿ. ಯಾರಿಗೂ 10 ಲಕ್ಷ ಯಾಕೆ ಕೇಳಿದ್ರಿ?
Who is none other than his advocate. He's appeared.
Advocate 10 lakhs ಕೇಳಿದ್ರ?
ಅಲ್ಲ, ಅವರೇ ರೆಪ್ರೆಸೆಂಟ್ KT ನಲ್ಲಿ ಮ್ಯಾಟರ್ಗಳು ಆಗ್ತಾ ಇದ್ರು. ಅವ್ರದ್ದು ಅಡ್ವೊಕೇಟ್.
ಏನಕ್ಕೆ ಕೇಳಿದ್ರಿ?
ಈ ಮ್ಯಾಟರ್ ಸಂಬಂಧ
ಯಾವ ಮ್ಯಾಟರ್ಗಾರ? ತಹಶೀಲ್ದಾರ್ 10 ಲಕ್ಷ ತಂದ್ಕೊಡಿ ಅಂತ ಫೋನ್ ಅಲ್ಲಿ ಯಾಕೆ ಕೇಳ್ಬೇಕು? Why should a Tahsildar, a public servant, ask any person to give 10 lakhs?
Not in respect of.
TDS ಕಟ್ ಮಾಡಿ ಚೆಕ್ ಅಲ್ಲಿ ಕೊಡಕ್ ಕೇಳಿದ್ರ? ಇಲ್ಲ, ಕ್ಯಾಶ್ ಕೊಡಕ್ ಕೇಳಿದಿರ?
Not in respect of this subject matter.
Maybe with respect of any subject, sir. Why did a Tahsildar ask 10 lakhs to be given?
Lord,
and how has he gone on scot free till now?
Lord, one Umesh, he is the advocate of second respondent. He has filed applications before the KT and the transferring matter. He was retired, already retirement.
Sari.
Lord, 29/7.
ಈಗ ಈ ಕೇಸಲ್ಲಿ ಕೇಳಿಲ್ಲ. Audio recording transcript is very clear that 10 lakhs you have demanded. May not be from him. ಯಾರಿಂದ ಡಿಮಾಂಡ್ ಮಾಡಿರೋದು?
ಇಲ್ಲ, ಅವ್ರ ಹತ್ರನೇ ಮಾಡಿ.
Tahsildar has to be Umesh.
ಉಮೇಶ್ ಯಾರು?
Umesh is advocate, own advocate.
Own advocate. Own advocate.
Second respondent
is an advocate. He was appearing for Tahsildar in the service matter, KT.
All right.
So therefore.
ಅಲ್ಲ, ಅಡ್ವೊಕೇಟ್ ತಹಶೀಲ್ದಾರ್ ಇಂದ 10 ಲಕ್ಷ ಫೀಸ್ ಕೇಳಿದ್ರೆ ಅರ್ಥ ಇದೆ. ತಹಶೀಲ್ದಾರ್ ಅಡ್ವೊಕೇಟ್ ಇಂದ 10 ಲಕ್ಷ ಯಾಕೆ ಕೇಳ್ತಾರೆ?
ನಾಟ್ ಇನ್ ರೆಸ್ಪೆಕ್ಟ್ ಆಫ್ ಸಬ್ಜೆಕ್ಟ್. ಅದು ಏನಕ್ಕೆ
ಅಂತ ಅದೇ ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಆಗ್ಬೇಕು.
ಲೆಟ್ ದಮ್ ಇನ್ವೆಸ್ಟಿಗೇಷನ್. ವಾಟ್ ಹ್ಯಾಪನ್?
ನೀವು ಹೇಳ್ತಿರೋದು ಯುವರ್ ಓನ್ ಅಡ್ವೊಕೇಟ್ ಅಂತ. ಯುವರ್ ಓನ್ ಅಡ್ವೊಕೇಟ್ ಆಸ್ಕಿಂಗ್ ಫೀಸ್ ಆಫ್ 10 lakhs. whether ತಹಶೀಲ್ದಾರ್ ಕೊಡ್ತಾರೋ ಬಿಡ್ತಾರೋ ಬೇರೆ. ಅಡ್ವೊಕೇಟ್ ಇಸ್ ಎಂಟೈಟಲ್ಡ್ ಟು ಆಸ್ಕ್.
ಇಸ್ ನಾಟ್ ಫೋನ್ ಎನಿ ಫೋನ್ ಕಾಲ್ ಟು ಹಿಮ್. ಮಿಲಾಡ್
ಉಮೇಶ್ ಅಂತ ಮಾಡಿದಾರ?
ಅವ್ರ ಕ್ಲೈಂಟ್ ಮಾಡಿದಾರ. ಅವ್ರು ಉಮೇಶ್ ಇಸ್ ಕಾಲ್ ಟು.
ಹೌದು ಸರ್, ಅದನ್ನೇ ಕೇಳ್ತಾರೆ. 10 ಲಕ್ಷ ಯಾಕೆ ಕೇಳಿದ್ರಿ?
ಏನು ಮೇ ಬಿ ಫೀಸ್ ನಾಟ್ ಇನ್
ಫೀಸ್. ತಹಶೀಲ್ದಾರ್ ಯಾವಾಗಿಂದ ಫೀಸ್ ತಗೊಳಕ್ ಸ್ಟಾರ್ಟ್ ಮಾಡಿದ್ರು?
ನಾಟ್ ಇನ್ ರೆಸ್ಪೆಕ್ಟ್ ಆಫ್ ದಿಸ್ ಸಬ್ಜೆಕ್ಟ್.
ವಾಟ್ ಎವರ್ ಇಟ್ ಇಸ್, when did Tahsildar begin taking fees from clients?
After disposal of the appeal, he filed a complaint on 19th.
ಹೋಗ್ಲಿ ಬಿಡಿ, ತಹಶೀಲ್ದಾರ್ ಯಾಕೆ ಕೇಳಿದ್ರು ಅದ್ ಕೇಳ್ತಿರೋದಷ್ಟೇ.
ಅಲ್ಲಿ ಇವ್ರಿಗೆ ಫೋನ್ ಮಾಡಿಲ್ಲ. ಅದ್ ಹೆಂಗ್ ರೆಕಾರ್ಡ್?
ಯಾರಿಗೋ ಮಾಡಿದೀರಾ? ಮಾಡಿ 10 ಲಕ್ಷ ಕೇಳಿದಿರ? ಇಲ್ಲಿ ಟ್ರಾನ್ಸ್ಕ್ರಿಪ್ಟ್ ಅಲ್ಲಿ ಇದೆ.
ಮತ್ತೆ ಇವರು ಏನೋ ಮಾತಾಡಿದಾರೆ. ಐ ವಿಲ್ ನಾಟ್ ಪ್ಲೇಸ್ ದಟ್ CD.
ಇಲ್ಲ,
ಇವರು ತುಂಬಾ ಮಾತಾಡಿದಾರೆ. ಅದನ್ನ ತುಂಬಾ ಎಂಬ್ರಾಸ್ಮೆಂಟ್ ಆಗುತ್ತೆ ಕೋರ್ಟ್ಗೆ. ಅದಕ್ಕೆ ನಾನು.
ಹೌದಾ? ಇದು ಕೊಡಿ.
ಅದೇನೇನೋ ಮಾತಾಡಿದಾರೆ. ಐ ವಿಲ್ ನಾಟ್ ಪ್ಲೇಸ್ ಇಟ್.
ಏನೇನ್ ಮಾತಾಡಿದಾರೆ?
ನಥಿಂಗ್. ವಿತ್ ರೆಸ್ಪೆಕ್ಟ್ ದಿ ಟ್ರಾನ್ಸ್ಫರ್ ಆಫ್ ಖಾತಾ, ದಟ್ ಉಮೇಶ್ ಇಸ್ ಮೈ ರಿಲೇಟಿವ್.
ಬೇರೆ ತರ ಏನೇ ಇದೆ. ಅದಕ್ಕೆ ಐ ವಿಲ್ ನಾಟ್ ಪ್ಲೇಸ್ ಇಟ್. ದಟ್ ಒನ್ ಹರ್ಡ್ ಅಬೌಟ್.
ಬೇರೆ ಏನೇನು ಕೋರ್ಟ್ ಬಗ್ಗೆ ಎಲ್ಲ ಹೇಳಿದಾರ?
ಕೋರ್ಟ್ ಬಗ್ಗೆ ಎಲ್ಲ ಏನೇನೋ ಮಾತಾಡಿದಾರೆ. ಐ ವಿಲ್ ನಾಟ್ ಪ್ಲೇಸ್ ಇಟ್.
ಮಾತಾಡಿ, ತೊಂದರೆ. ಬಟ್ ಈ ಕ್ರೈಮ್ ರಿಜಿಸ್ಟರ್ ಮಾಡಿದಾರಲ್ಲ,
ಇನ್ವೆಸ್ಟಿಗೇಷನ್
ಕೋಆಪರೇಟ್ ಮಾಡಿ. ಇನ್ವೆಸ್ಟಿಗೇಷನ್
ವಿಲ್ ಕೋಆಪರೇಟ್.
ಅದ್ರ ಪಾಡ್ಗೆ ಅದಾಗುತ್ತೆ.
So far as this case is,
I will quash this.
Lord, that is only I objecting.
ಏನು ಹೇಳಿ?
Lord, 29/7/2024, one Nanjundappa sons is filed application for transfer of revenue records. One Prasanna, as per annexure R2, my lord, Prasanna is filed statement of objections to objecting for transfer of Khata. My lord, then Tahsildar initiated the proceedings, RRT proceedings. Then that proceedings, the advocate is petitioner is appeared. He asked for genealogical tree and other documents. He is objected for producing that. My lord, then my lord, 15/10/2024 order sheet speaks. He passed the orders saying that entire the Khata was not rejected. Passed order in favor of the applicant, saying that property Khata to be registered the family members of the He's objecting is that, my lord, he want to register in one name. Against which that order, my lord, he filed appeal also before the assistant commissioner. Then, my lord, after disposal, my lord, 18/10/2024, he want to advance the application. That only some
Altercations have
altercation.
happened.
Then the Tahsildar has filed a complaint.
Ashtana, sir.
Yes.
When he has not received the complaint, he lodged the complaint before the Lokayukta saying that he demanding 10 lakhs.
Correct ಆಗಿ ಇದೆಯಲ್ಲ ಅದು
After disposal.
ಆಡಿಯೋ ಟ್ರಾನ್ಸ್ಕ್ರಿಪ್ಟ್ ಇದೆ.
After disposal of the
ಪ್ರೀಪೇಡ್ ಪೋಸ್ಟ್ ಪೇಡ್ ಒಟ್ನಲ್ಲಿ ಕೇಳಿದ್ದ ಹೌದು.
No date, time, nothing, my lord. Let them investigate the matter, my lord.
ನಿಮ್ದು ಇನ್ವೆಸ್ಟಿಗೇಟ್ ಮಾಡ್ಲೇಬೇಕು.
ನಮ್ದು ಮಾಡ್ಲಿ,
ಅವ್ರದ್ದು ಯಾಕೆ ಮಾಡ್ಬೇಕು? 353 is the allegation. ಏನ್ ಬೈದ್ಬಿಟ್ರ ಇವ್ರು ನಿಮ್ಗೆ?
ಗಲಾಟೆ ಮಾಡಿದ್ದಾರೆ ಅವತ್ತು ರಜೆ.
ನೀವು 10 ಲಕ್ಷ ಕೇಳಿದ್ದು ಗಲಾಟೆ ಮಾಡ್ಲೇಬೇಕು.
ಅವ್ರು ಕೇಳಿಲ್ಲ, ಅವರು
Anything else? Yes, the petitioner, a practicing advocate appearing in person is before the doors of this court, calling in question the registration of a crime in crime number 223 of 2024 registered for offences punishable under section 132 of the BNS, which is 353 of the earlier regime, the IPC. Facts in brief, germane, are as follows. The second respondent is the complainant. The petitioner, the second respondent, the Tahsildar, Ajjampura police, Ajjampura Taluk, is the complainant in the case at hand. The petitioner appears before the Tahsildar seeking mutation of kata in favor of the legal representatives of his client. It transpires at that point in time there are certain altercations between the petitioner and the Tahsildar. The Tahsildar passes an order against which the petitioner is said to have preferred an appeal. Appeal is in your favor?
Appeal is said that Tahsildar order is set aside and remanded back to the
appellate authority, the assistant commissioner sets aside the order of the Tahsildar and remits the matter back to the hands of the Tahsildar for consideration of fresh of the claim of the petitioner's clients, petitioner's clients. After the said remand, the petitioner registers a complaint before the Karnataka Lokayukta with certain evidence of conversation recorded in a compact disc to the Lokayukta, recorded in a compact disc, alleging that the second respondent Tahsildar had demanded rupees 10 lakhs as alleged bribe, not from the petitioner but from one Umesh. The recording was not taken to its logical conclusion, nor a crime was registered against the Tahsildar. In turn, the crime was registered against the petitioner for alleging that the petitioner has raised his voice or has abused the Tahsildar who was performing his public duty at the point in time, and therefore the complaint becomes a crime in crime number 223 of 2024 for offence punishable under section 132 of the BNS 2023. It is at that juncture the petitioner is at the doors of this court calling in question the registration of a crime in crime number 223 of 2024. The petitioner in person would contend that the Tahsildar has registered the subject complaint as a counterblast to the complaint so registered by the petitioner before the Lokayukta, which had not yet resulted in registration of a crime. He would submit that none of the ingredients as is necessary in law as laid down by the apex court in several judgments is met in the case at hand insofar as it concerns the offence under section 132 of the BNS bracketally 353 of the IPC. Per contra, the counsel appearing for the second respondent complainant, the Tahsildar, would submit that the petitioner has in fact hurled abuse upon the Tahsildar at the time when he had visited him for preponement of the case after the remand from the appellate authority.
After disposal.
after the Tahsildar dispose ಮಾಡ್ಬಿಟ್ಟಿದ್ರು.
ಅವ್ರು dispose ಆದ್ಮೇಲೆ he filed a complaint.
After the disposal,
ಇರ್ಲಿಲ್ಲ ಅವ್ರ ಹತ್ರ.
after the disposal of the proceedings before the Tahsildar, he would submit that it's a matter of investigation, and the investigation, the court should not, in exercise of its jurisdiction under 482 of the CRPC, interfere at this stage of the proceedings. The learned additional SPP and Jagdish would also submit that the matter is still at the stage of investigation, and therefore this court should not interfere with the said proceeding. I have given my anxious consideration to the submissions also. The afore narrated facts, link in the chain of events, and the dates are all a matter of record. What drives the petitioner to the Lokayukta is the complaint so registered by him. The complaint?
Annexure C page.
Complaint registered by him, Annexure C, page 18. The complaint the narration in the complaint is that the Tahsildar has hurled abuses and has demanded money. The Lokayukta does not take any action. In turn, the Tahsildar registers a complaint on 19/10/2024 against the petitioner for alleging that the petitioner has spoken in loud voice and abused in the chamber of the Tahsildar. In the chamber of the Tahsildar. So, Tahsildar, therefore, it becomes a crime in crime number 223 of 2024. The issue now would be whether the complaint so registered, the complaint so registered by the Tahsildar, the complaint reads as follows. 19/10/24 reads as follows, page 12. The complaint so registered by the Tahsildar would meet the ingredients of section 353 of the IPC/132 of the BNS. Section 353 of the IPC directs or punishes a person who would stop a public servant from performance of his duties by use of criminal force. The criminal force or assault, as the case would be. Section 349 to 351 define what is assault and what is criminal force. If the ingredients as is found in section 349 and 351 are noticed, none of those are present in the complaint so registered against the petitioner. Therefore, it would not become an offense under section 353 of the IPC or 132 of the BNS. Permitting further proceedings against the petitioner would be permitting a complaint that is registered as a counterblast to what the petitioner had registered against the Tahsildar before the Lokayukta. The apex court in the case of Bhajanlal was State of Haryana was Bhajanlal 1990. Para 102 extract yes, has laid down 7 postulates of entertainment of a petition at the stage of crime in exercise of jurisdiction under section 482/528 of the BNS. In the light of the law so laid down by the apex court in Bhajanlal as the apex court considering what would be the purport of section 349, 351 and 353 of the IPC has in SLP 5905 of 2022 disposed on 21/10/2024 in the case of KV Dhananjay versus State of Karnataka has held as follows. Paragraphs held in the light of the law laid down by the apex court in the case of KV Dhananjay versus State of Karnataka, which applies to the facts of the case at hand on all its force, FOURS, on all its force. Permitting further proceedings would become an abuse of the process of the law. It would become apposite, APPO, apposite to refer to the judgment of the apex court in the case of State of Haryana versus Bhajanlal. So in para 102 clause 157 highlight madi. In the light of the aforesaid judgments, the apex court, I deem it appropriate to exercise jurisdiction under 482 of the CRPC and obliterate the crime against the petitioner for the aforesaid reasons allowed quashed. Yes.